My name is Todd Sinkins. I'm an attorney with Reese Broom. Represent associations in DC and Northern Virginia. With me is Scott Burka, the president of EJF. And so we're going to spend some time talking about the requirements of the Corporate Transparency Act, where things stand currently with the obligations to comply with the act. What we anticipate to happen over the next 12 to 18 months, and sort of your options for associations to comply. So with that, let's get started. So the Corporate Transparency Act was enacted as an amendment to the Bank Secrecy Act. It was enacted in 2021. Its professed purpose was to essentially make it more difficult for smaller business entities to engage in money laundering. And the way that Congress decided to address this was to create a reporting requirement for those type of entities to provide the names of the people controlling those entities and certain contact information about those people to the Department of the Treasury's Financial Crimes Enforcement Network. FinCEN adopted regulations to implement that law, and the law became effective January 1st. So the type of entities that must comply are U.S. corporations, U.S. LLCs, any other similar entities that essentially if they're created through a filing with the Secretary of State or any similar office under the law of any state or Indian tribe, and for non-U.S. entities are registered to do business in the United States. It's going to vary from state to state, but most community associations are going to be required to comply with the obligation to submit this information, which is called beneficial ownership information, to FinCEN. Next slide. So there are some exceptions. If an association has more than 20 full-time employees and gross receipts that exceed $5,000, they're not going to be required.
5 million.
I'm sorry, 5 million. Sorry about that. Also, if an association is a tax exempt entity under Section 501 of the Internal Revenue Service Code, they're also not required to comply. Essentially, communities or entities that have those characteristics have already are subject to other regulatory reporting requirements with the federal government that mean that they don't need to comply with the statute, and they're expressly exempt under the statute. Many community associations can't meet these requirements of having both more than 20 full-time employees and gross receipts in excess of $5 million.
So let me jump in here for a second. So
Sure.
I'll sort of break down the legalese. The bottom line is this is new legislation that, as Todd said, goes into effect January 1 of next year. It's going to be a big deal for this industry.
Scott, it went into effect January 1st of this year.
I'm sorry, correct. January 1st of this year, but people will have to comply by January 1 of next year. Beneficial ownership, that's sort of a key phrase because management companies have for quite some time, maybe even going back to the Patriot Act after 9/11, had to fill out beneficial ownership form every time we open a bank account for a association. And we're obviously not beneficial owners, but most of the banks in the industry will accept the management company registering as the beneficial owner and providing either our corporate tax ID number or a principal's actual social security number. And so management companies have been complying with aspects of beneficial ownership for some time now. This is going to take it down to the board member level.
Yeah.
unless you have an exception or exemption, as Todd was just talking about.
Yeah. Now let's talk about that, in terms of what individuals have to comply. So beneficial ownership comes in really two different, is based upon two different pathways. One is if somebody directly or indirectly exercises or owns or controls at least 25% of the ownership interests. That's usually not going to be the case with the community association, but can on occasion be the case.
If you're 4 units, you would be 25% owner.
Right. Yeah, or they'll keep in mind, particularly from a condominium perspective, if there's an investor owner that owns in an aggregate 25% or more of the common element interest, they also be required to, they'd be defined as a beneficial owner. The other is if they exercise substantial control over the operations and management of the association, and that's where board members fit within the definition. As the statute is defined, I think board members of associations that are required to comply do meet the definition of a beneficial owner. And so, one of the a board member who gets elected to the board then will have 30 days, and I'll get into that a little bit later. We'll get into that a little bit later, to have their information registered with FinCEN. There's some details about it, about substantial control, serving as an officer, having direction or determination or decision power over substantial influence over important matters affecting the company or entity. I mean, and that's really going to be a key there, because board members certainly do that. And so that's how board members are defined as a required registrant under the CTA. Next slide, please. And this is some other sort of descriptives of the type of things that fit within that. Next slide, please.
So just real quick,
Yeah.
Again, a board is going to have oversight for major expenditures.
Yeah.
Incurrence of debt, taking on a loan, all of these kinds of things really suddenly put board members under this catch-all to be obligated to participate in the CTA.
So here's some exemptions. And most of these don't apply. But the second and third bullet points are important to understand. And this is, individuals acting as an agent have an exemption, and the statutory language is agent for person. Now, because of the interpretation of federal law, I believe that, in my opinion, agents for associations are exempt from compliance based upon the exemption in the Act. Although I know that there's been some debate and discussion on that topic throughout the industry. Also, employees employees of associations are not deemed to be beneficial owners unless they have other relationships with the association might otherwise cause them to be, which in our context is very, very unlikely. So it is so there are these certain exemptions. Most of them don't apply. And for board members, I don't think any of them would apply to a board member. So board members of associations that meet the minimum or below the maximum employee number and below the maximum revenue number will be required to comply under the Act. So here's what needs to be disclosed. The full legal name of the individual, the date of birth of the individual, their current address, and it can be either their business address or residential address. And at least on first application, it's going to be either an unexpired passport or driver's license. And once they have filed, then they'll be issued a FinCEN identifier number that then can be used for subsequent registrations. For board members, that's probably not going to be triggered unless they've previously registered for another entity. But if they've previously registered for another entity, then they'll be able to use that FinCEN identifying number moving forward for any subsequent registrations.
A hypothetical example of that would be if you were a board member serving on two different association boards. That would, in that kind of scenario, you could get your FinCEN identifier number and use that for both entities.
Yeah, actually, we're going through the process of handling several registrations for associations that were all developed by the same community and are still under developer control. And so those individuals who serve on those boards already have a FinCEN identifier number. And so we're able to do it through simply submission of the FinCEN identifier number, which then has a benefit once it's been done once of sort of just populating the database with all the information of that individual, since they already have a number and already in the database. So deadline for compliance is December 31st of 2024. That's for any association that existed prior to January 1st of 2024. For associations that were created on or after January 1st of 2024, they had 30 days. Well, actually now it's 90 days from the date of creation to register. When there is a change, when a board turns over and somebody meets the definition of a beneficial owner that did not meet that definition before, then they'll have 30 days from that date to register their information with FinCEN. So like, for example, if you have an annual meeting, if you say you were to register on June 1st, and then you have an annual meeting on October 1st, you would have until October 31st for anybody elected at that October 1st annual meeting to register their information with FinCEN. So there's been challenges to the statute, one of which has gone through and there's been a decision at the trial court level. On March 1st, a judge in the Northern District of Alabama, in a case called the National Small Business Association versus Yellen, ruled the CTA is unconstitutional. In that decision, though, they limited the application of their decision to only the plaintiffs in that particular case. So it was limited to either the NSBA itself and the members of the NSBA. Okay. The basis for that decision was that the judge found that the CTA was unconstitutional, essentially based upon the argument it violated the Interstate Commerce Clause of the Constitution. That case was appealed in the 11th Circuit. Both the NSBA and the Department of Justice have filed their briefs in that case. CAI, the Community Associations Institute, is filing an amicus brief in that case. Its brief is due on Monday. I actually have drafted a portion of that brief along with 4 other lawyers from around the country, arguing on behalf of the position taken by the NSBA that the CTA is unconstitutional. Matter of fact, I believe that CAI has a stronger case than actually the NSBA does to argue that it's unconstitutional. And I would say stay tuned as to whether or not CAI might file its own lawsuit. So from a timing perspective, while this is all great, it's going to take time for this or other cases to move through the court system. My estimation is that the earliest that a case from the 11th Circuit would be appealed to the Supreme Court would be for the October 2025 Supreme Court docket, which means at the earliest we'd have a decision of the Supreme Court on whether the CTA is constitutional or not would be in June of 2026. So from a case law perspective, I do not believe that the CTA will be ruled to not require compliance for essentially 2 years from now at the earliest. Next slide, please.
So just to jump in here for a second and to break this down, management companies across the country have been following this since really late last year. When the decision came out on March 1, there was hope that this would all go away for community associations. But as of right now, that has not come to fruition. Additionally, correct me if I'm wrong, I think the House put forward a motion or a
Yeah.
bill.
Yeah, Scott, that's actually the next slide if you want to move on. to the
Okay.
next.
Yeah, so the House of Representatives passed legislation to delay the date by a year. Truthfully, there's a lot of us in the industry that think that FinCEN have no idea what they're getting themselves into. I know, Todd, you threw out the number of like 100 million, registrations that would have to be done over the next roughly 7 months or so, 8 months.
That's the number I've heard. I mean,
Yeah.
it's a big, broad, round
Right.
number, but
So,
it's a massive number of people.
and it's a massive amount of data for the government to process. There was a companion bill introduced in the Senate back in January, but it doesn't have sufficient support to pass. So, management companies and CAI are urging folks to notify their politician, as it were, and just explain that it's a little ridiculous that if you're living in a condo building, you might actually be, thought of as the same basis of, a money launderer. So while there are legal challenges to the enforceability, as Todd said, the best chance is that something goes into effect in 2026. And at this point, I think management companies, as of sort of April of this year, are starting to contemplate how they're going to and to what level they're going to be involved. And we'll talk about that more in a few slides.
And Scott, on that last point, with respect to the legislation, it's funny. It's been sort of like the perception of the level of support sort of has varied almost week to week. So in April, I'd heard some indication that Senator Schumer's office was supportive of a delay or even an exemption bill for associations. But then in the appeal in the 11th Circuit, Senate Democrats filed an amicus brief supporting the government's enforcement of the CTA, which suggests to me that right now there's not an appetite for or support for any bills in the Senate to create a delay or an exemption for the CTA. So this slide here, we're talking about, what's called personal identifying information, passport numbers, license, driver's license, names, addresses. Those all meet the definition of personal identifying information for homeowners. And so because of that, because associations are going to be in receipt of that information so that their board members can comply with the registration obligations, it's going to be imperative for associations to work with their management companies like Scott and his folks to ensure that protocols are put in place to protect some of this sensitive information. And Scott, I know that your company already has to do that in a whole host of other areas such as banking information, credit card information. To address that type of thing.
Yep, absolutely.
So I mentioned earlier that there's an obligation, there's basically an ongoing obligation to update this information. So if there's any change in the information with respect to beneficial owners, it has to be filed within 30 days of that change. So if there's a change in who's on the board, that has to be filed within 30 days. If existing board members change any of their information, such as their address, that would have to change and be filed. And so it's going to be important for boards to work with their managers to ensure that they have protocols in place to timely file these updates. Also, if a board or management recognizes that some of the information that was disclosed was inaccurate, inadvertently, there is an obligation to correct that within 30 days of the day that they realize that there was an inaccuracy in their filing. So, I mean, I think that there's always going to be a triggering point with the annual meetings. At most annual meetings, there's at least some turnover on the board. So once there's turnover after the annual meeting, there's gonna be 30 days to update information. If a board, as I mentioned earlier, if a board member resigns and is replaced, that's gonna have to be updated within 30 days as well.
The bottom line, it becomes a huge administrative nightmare for management companies because there's such a short window. And while, as Todd pointed out, we're already, storing PII as necessary through things like bank accounts and so on, there is talk within the industry about whether or not management companies want to take on further liability with all this and have the responsibility for reporting in 30 days or pushing it back to the board or pushing it back to the board's legal counsel or what. There are some entities that have been set up that are looking to, provide services. We'll talk about that in a little bit too. Now, operationally, there are things that we as a management company now need to be thinking about. Because some people may not want to give their PII to FinCEN, although some people might argue the government's already got all my information anyway through global entry, TSA pre-check, fingerprinting, facial scans, etc. But we're going to be recommending, for example, that when we do call for nominations for annual meetings, that there's a disclosure that talks about FinCEN and beneficial ownership requirements. We're looking at the fact that we may have to move up annual meetings and hold them, instead of holding them November, December, maybe hold them September, October. There are a lot of operational considerations in this legislation moving forward. And of course, we expect, I think everybody that's in the industry expects this to have a chilling effect on volunteerism. It's just, board members get those big salaries, not. And so why put yourself through one more disclosure, one more headache? We hope we're wrong on that, but it has been a point that we've tried to emphasize with the government as an industry that this is an industry big on volunteerism, and this could have a significant impact.
Something just to highlight for folks. The law also for new associations and really any new corporation created after January 1st, their individuals had to be registered within FinCEN within 30 days of their creation. The initial deadline was March 31st, and then thereafter within 30 days. How that applies here, really for newly formed condominiums, cooperatives, and homeowners associations. Once that they've been created, there's gonna be 30 days to register. And so, the extent that Scott and his folks are working with developers in particular. They're gonna be, some discussions had, I think, at the very outset to make certain that the registration has occurred. And at least what my experience has been, is that most of at least the developers councils that I have had interaction with on this have not been prepared at this point to do this. So they're actually sort of pushing that to find other counsel to handle the registrations for the entities that they're forming.
So we've shared with you, what this is all about. And while most people are probably looking at this thinking it's a pain in the rear, and we're just a small association, or, does the government really have time to track us down? They've made the penalties really significant.
Yeah.
So go ahead, Todd.
I was just gonna say, what's unusual about this is that they made these penalties criminal in nature, which actually, by the way, is one of the arguments against its constitutionality. The penalties are are so far beyond any other penalties for these others than these types of registration requirements you might otherwise find for community associations, as to be somewhat shocking. They're willful violations. That's when someone knows about it and just decides they won't do it. I mean, could subject them or the association or both to fines of up to $250,000. And also could subject them to incarceration, potentially. Even for inadvertent failure to comply with some limited safe harbors. There could be a $500 per day fine for failure to register by the deadline specified in the statute. So, my view on this, and I think that Scott, you would agree, is that this is not something that boards can or should push aside or ignore because it's an annoyance, a pain in the neck, as you said, because the penalties are just too severe. And it's frankly one of the reasons that, for several months now, when I've had clients going through the 2024 annual meetings, I've been drafting and providing to managers language for the calls for candidates indicating precisely what Scott was describing before, that if you are elected to the board, you are going to have to provide this information.
Yeah.
So that's an important thing to be cognizant of, and everybody serving on the board that's on this meeting right now, you're going to have to do this before December 31st at midnight. And that's the penalties for failing to do so are just way too severe.
Now, circling back for a minute to some of the operational considerations, I mentioned some of them before: changing annual meeting dates if permitted by the bylaws, disclosure of the obligation to file with FinCEN on our call for nominations, inclusion of the obligation and consequences for failure to comply, because as we just noted, they are significant, and possible inclusion of obligation to comply actually built into your bylaws through a bylaw amendment. And what do you do if a board member refuses to comply? I don't know the answer to that right now. You've got a 5-member board or a 7-member board, and one person says, I'm not giving up my PII. Suddenly we're going to have a lot of boards, potentially have a lot of boards who are going to have to appoint new people. And those people have to be people understanding what they're going into. So there's a lot here.
And the tricky part in that last one, Scott, is what if a board member refuses to comply and refuses to resign? I think under those circumstances, I've had that question posed to me, and what I've at least advised the clients that have posed that question to me is you've really got two choices. And that's one, to pursue a removal of that person in accordance with the provisions in the bylaws. And that's probably going to require a member vote in all likelihood. Or file a lawsuit against that person for breach of fiduciary duty. Because I think it's certainly breach of fiduciary duty if they knowingly fail to comply with an obligation contained in federal law that subjects the association to civil and criminal penalties. And so, I mean, they're not great options, but that's what exists. I mean, I think one sort of in the category of unanticipated consequences, I mean, it creates a situation where potentially where associations might have to be having internal conflict within the board and within the association to ensure that the associations are not going to be subject to penalties that are severe. And frankly, particularly since community associations were never the target of this law. Target of this law was small, closely held corporations where money actually was funneling in and out and were being used for money laundering. You know, particularly, sort of small real estate companies are particularly well suited for that type of thing. That was, I think, at the center of some of this, but also other types of small, closely held businesses. But because they were so lax in their definitions in the statute, community associations are trapped within the umbrella of the obligations. I don't know this is true. My supposition has been that when they wrote the language to create the exemption for tax exempt entities, I think they thought they were applying it to a broader range of not-for-profits, which is what most of our associations are. They're not for profit, but they're not tax exempt. And that's, I think all those are sort of challenges that sort of arise out of the law. And I really do think that it's the difficulties that this industry is going to face are a result of an unintended consequence of the adoption of this law.
So assistance and compliance, as I said, I think most management companies have been holding off, certainly in the first quarter, to see where some of the legal maneuvering was going. I think based on other calls that I've been on in the last few weeks, management companies are now looking at this and starting to say, okay, we've got to circle back and figure out how we're going to do this and start really pushing to talk to our clients on it so that they're aware. Again, if we have to move up meetings or change language on call for nomination forms or other things like that. As noted here, Reese Broom is going to be offering services to assist their clients. I've heard of only a few law firms that are willing to do that. Some are just saying we don't want to take on the responsibility / liability. And where EJF is right now is we're looking at various platforms, including working with Tom's firm and other outside entities, just to see what our options are. I was on a phone call yesterday with our software company, Vantica. They're exploring how they can assist all of their management company clients in undertaking this over the next 7 months. So there's going to be more to come on this. We wanted to get this presentation out now with some of the legal dust settling down and knowing that, we're going to have to find a way to get our clients to comply by the end of this year. And we'll be sending out more information through our managers' weekly reports and likely additional webinars. Mayor, do we have any questions?
There's none in the chat, but I guess we can raise this moment to say, if you'd like to ask a question directly, you can raise your hand and we can take you off mute, or failing that, you can drop a question in the chat and I'm happy to bring that up to Todd and Scott.
All right, as we're waiting to see if anybody has any questions, my other one takeaway for the board members on is please go back and take this information to your other board members. As Mira said at the beginning, we'll have this available on our website as a recording, but part of our job as a management company now is making our clients aware of this, getting the word out, and helping boards understand what's coming down the pike in the next several months.
Hey, Scott.
Okay,
uh,
so we've been asked if we can repeat the penalties.
Sure.
And
Yeah, I'm happy to do that. So there's a $500 per day fine for failure to comply. That is gonna apply when it's not a willful violation of the act, so more of an inadvertent situation. If there's an intentional violation, if you know of it, and you just refuse, then the fines can be up to $250,000. And it also can result, it's a felony that could result in up to 2 years in jail. I have no idea if there will be prosecutions arising out of this that are gonna be demanding incarceration, but the statute does call for that.
And I
Todd,
think
is it the individual or the association that's going to bear those
Statutes.
fines?
The statute's not actually clear on that. I think that both are potentially subject to it.
Thank you.
There's also another question about whether or not it applies to cooperatives. The answer to that's certainly yes,
Yes.
because cooperatives are incorporated. They're clearly and squarely within the scope of the statute.
And then how secure is, oh, I'm sorry, Scott, did you have something to add to that, those answers? I
No.
apologize.
No, that's all right.
Okay. How secure is the FinCEN site if a board wants to register the information directly? Are boards able to do that, Todd?
Yeah, you can go to the FinCEN site and log on directly. In terms of how secure, I can't really speak to that. I mean, I'm not a technologies person. I don't have any way to sort of, I know it's intended to be secure. They represent that it's secure, but I don't know if in fact it is completely secure or not.
Alice, you had a follow-up. I've taken you off mute if you'd like to follow up on that.
Seems to me that you guys are really suffering over this issue of PII and wrapping yourselves around the axle. And I understand, the legal implications. But, given all of the stuff that we as individual taxpayers and, people who have to comply with so many federal and local laws, we're sort of used to giving our PII up directly, every time we register for whatever it is. And I don't see why the FinCEN process should be any more vulnerable than the IRS or anything else. So I'm just wondering if anybody has actually gone online and tried to register. I mean, so they can speak from experience. I'm almost tempted to do it myself and see what the process involves.
I mean, we have people from my law firm that have done it for our existing clients. I just don't mechanically do the handle the registrations, and we have a paralegal that handles that for us.
Yeah.
But what I'm saying, what I'm made to say, I can't speak to the security of it.
Yeah.
I mean, I can't. I mean, I don't. I mean, that's a technical question that I don't.
No, and I think we talked about this earlier on, as I mentioned during the presentation. Look, I just, flew somewhere and I used TSA PreCheck, and so I hand them my driver's license and I stand in front of the camera and they do facial recognition. So to some extent, you're absolutely correct, Alice. The government, for the most part, has a lot more PII on us than we, want to acknowledge maybe. But that's not to say that the disclosure that's now a requirement for you to give additional PII to the government, just so you can serve as a volunteer board member. There is concern across the industry that will impact volunteerism.
Oh, no, I absolutely understand that, we're talking about two different things. One is, comply or die. And while we're waiting, hopefully, for a legal challenge to take effect and save us, it's not going to save us before December 31st. So I'm just looking at it from, a long-time board member position of, we may just have to bite the bullet and we just register ourselves.
Yeah, and the other thing, just coming back to the operational considerations, is that, let's just say you've got a board that is totally understands all this and is okay with it. The other side of this is, we don't want to really register you now before you have your annual meeting, because if I register you tomorrow with your current board members and 3 members go off at a November annual meeting, then I've actually got to register you twice. And there is a cost for it. It's a few $100s. It's not exorbitant, but there's cost for that. And so part of this, again, from an operational standpoint as a management company is, having the boards think about when they're holding their annual meeting and when they're registering. We can't have everybody try and register December 15th, you
Yes,
know?
we're
Yeah.
good because our board is set until January of 2025. That's when our annual meeting is. So we could register tomorrow.
Right. And then you'd have to register again, the day, within 30 days of your annual meeting in January.
Yeah, but we'd meet the deadline, which is the
Yes, correct. Yep, absolutely. Other
So,
questions?
2 quick things on this. I took a quick look while we were talking at the FinCEN site. It's 50 questions, and an upload. So depending on how much, you have for your beneficial reporting, it depends on probably your faculty with with those kinds of uploads. But, we had a question about, is there a penalty for wrong information? Like if you accidentally transpose a number or something? I don't know if you would
So
know that, Todd.
that's actually fairly clear. I mean, first of all, there's not a penalty immediately. I mean, once the association or other entity becomes aware that their information is incorrect, they have 30 days to fix it. And then after 30 days, then there might be a penalty. That penalty would be the $500 a day fine, I think.
Okay, and then do associations file as a unit or do members do it individually?
Board members would typically do it individually. I mean, we need to submit each board member's information separately.
Okay. And then Scott, you apparently referred to cost of registration.
Mhm.
Do you know what the costs are?
I do not.
Okay.
I mean, I
didn't
can
notice
speak
that
to
when it
what our,
was-
I mean, it's not a cost charged by FinCEN. I mean,
Right.
you're gonna have costs by whoever is assisting the association
Yeah.
clients. I mean, I can tell
Got
you
it.
what our fees are. Ours are $350 per year plus $50 for any in-year update.
Okay. And then interesting question. What happens if an association can't seat a board because of this?
Anybody? That's a complicated question. I mean, I would say this, if the board members absolutely refuse to comply and therefore there's going to be no board members. And I think that as fiduciaries, the last act of that board prior to there being no directors, nobody willing to serve, would be to probably direct their counsel to file an action in their local court to have a receiver appointed to operate the association in lieu of a board of directors. And that's going to cost the association a lot of money.
And then the question was, where do we actually register, which is fincen.gov, right, Todd?
Yeah, yeah. And if you want to try to do it yourself there, you absolutely can. If you want assistance from an outside party, then you can seek those out.
Okay, that was the last question in the chat. So I don't know if anyone else. Oh, wait. Will today's presentation be sent via email today? Hopefully, Sylvia, it will definitely be in our Friday updates tomorrow. I will, as soon as we're done with this, it takes Zoom a little bit of time to process the recording, but we'll send out an email when it's posted to our website like we usually do. Yes, Jane Silver, I can unmute you. Go ahead, Jane. You have to unmute yourself, but I've allowed you to talk, sorry.
Am I unmuted?
Yes.
Yes, ma'am.
I hear you.
Thanks so much for this. This has been extremely helpful. I'm the one who asked the question about whether we file as an association or individually. My question wasn't whether you had to file each of our information, but it was whether you filed all of the board members together. Or does it not matter at all?
Each board member has a separate FinCEN registration. So like I'll tell you how we've done it mechanically, because we've already done this for a few associations. We communicate individually with the board members, tell them the information we need. They then submit it to us. And then for each individual, our paralegal team submits that app information referencing the corporate entity or the association that they're registering for. And so each registration is done individually for the association.
I got it. So it could be, I mean, I think it's too soon to try to figure this out because luckily EJF is trying to help us figure it out together. But if in fact there is no intermediary, not EJF, not you, not our attorney, and we had to do it ourselves, we could, there's a place where we say what we're doing it for, and we could all do it individually. I'm not suggesting we
That
want.
is correct.
Yeah,
Yeah,
I'm not
that's correct.
suggesting we want to do that. I just wanted to know if somebody asked me the question, what the answer is. Thank you.
That's
again.
correct.
Yeah,
yes.
thank you again. This has been unfortunately very informative.
One more question, guys. Limited equity co-ops are also impacted, right? It doesn't matter if you're.
It's dependent
Okay.
upon it's dependent upon whether or not they meet an exemption. But if they're not a 501c tax exempt entity, and if they don't have at least 21 employees, and if they don't have more than $5 million in revenue, then they're going to have to comply.
Okay. Okay.
Yeah, because as I said earlier, all cooperatives are incorporated.
Right. All right. I don't see any more questions in the room. But if you think of anything, you can always email EJF and we will help you out with any questions. And as Scott said, we are definitely looking into how we're going to be assisting our clients with this, with compliance. So thank you all for taking time out of your busy days. Sylvia, the question is, does it matter if the co-op was incorporated in Delaware? No, this is for it. That doesn't matter, right, Todd? That's
Correct.
it's everybody.
Correct.
Okay. So again, thank you all. As I said, as soon as we can get this posted on our website, we will, and we'll send an email to all our board members that it's available. And as Scott said, I think it's very important that you go back to your colleagues and let them know about this, particularly the annual meeting thing. I think this is going to have an impact this year for a lot of our clients. So last thoughts, gentlemen?
No, thank you all. We'll, EJF will be putting out updates, and feel free to reach out to us with any questions. And thank you, Todd, for being on the call.
Thank you. Yeah, and if we've been sending out newsletters to our clients on this topic. We sent one out in March to our Reese Broom clients and previously in September of 2023. And I suspect we'll do so once or twice more throughout the year.
Awesome. Thanks again, everybody.
Bye-bye.